This is case 2011-0833, in re name change of Alexander Goudreau.
The record should reflect the fact that Justice Conboy is disqualified. Mr. Gordon?
Thank you. May it please the court, I'm Joshua Gordon. I represent Veronica Goudreau, the young mother. I'd like to reserve 2 minutes for rebuttal. I've notified the clerk. During pregnancy, Andrew, the father, was not involved at all. He expressed to Veronica his disdain for being a father and expressed no interest at all in the choice of name. So Veronica did what mothers do. She gave birth, chose a name, had the baby baptized. She didn't do anything inappropriate or hostile. Consequently, Veronica has primary residential responsibility. The custodial parent is presumed to act in the child's best interest, and this context should be no different. The practical realities of day-to-day parenting is getting the child to the doctor, entering him into daycare, registering for school, signing up for a cell phone plan. The custodial parent is the one most often doing those things, and as a practical matter, a child with a different name from the daily parent has an extra burden on every form he fills out.
How can you distinguish this child from the child of any divorced mother, let's say, who remarries and takes her new husband's name?
There's no dispute there. There is an extra burden.
But if you're talking about practical daily reality, that child is in the same situation as this child.
Absolutely.
Okay.
But in those cases, that family doesn't dispute the name.
Well, but if we do what you want us to do, isn't that, likely? I mean, my understanding is that many years ago, there was very few incidences when after parties were divorced that the woman asked to return to her maiden name. But now that's quite common.
Right.
So if we go the way you go, I mean, aren't we, isn't there a likelihood, maybe even a substantial likelihood, that we're going to have a number of situations, at least where the child is not particularly old, maybe, say under 5 or under 6 or something, where the custodial parent, if the child has the other parent's name, is going to be filing these petitions saying, I want the child's name changed because I'm the custodial parent?
Well, because these cases, at least in New Hampshire, don't come up very often. There are cases in every jurisdiction. But apparently, lots of families don't dispute these things. So I don't know that there's some, if I understand your question right, I don't know that there's some, huge number of sudden cases that are going to come out because if this court does what I suggest, which is create a presumption like New Jersey's, where where the choice follows naturally and automatically follows the custodial parent, which is just the most convenient way to do it. And if there's a problem, the non-custodial parent can overcome the presumption, by proving best interest. But I think that the New Jersey formulation sort of gives just makes the name, when it's disputed, just follow the custodial parent, and it will lessen the
Let me ask you
possibility of lawsuits.
Why don't we try to think a little bit outside the box here, and, for example, say, okay, you folks, you can't agree. That's really too bad for your child. And so here's the rule. If you can't agree, the child's name is going to be hyphenated. Might get really long and syllabic, but it'll be hyphenated, and counsel can flip a coin to decide which name comes first.
Well,
that would certainly take the best interest concern out of everybody's hair, and it would be fair, wouldn't it?
Well, yes, but it doesn't sound to me like it has a lot to do with the rule of law.
Well, we're creating law here.
Yeah.
These folks come in, they say, we can't decide, we're both the parents. You don't like the facts about the father. He probably doesn't like some facts about the mother. I'm not sure that's our concern. We're supposed to decide how this baby should be named.
Right, and that's precisely the reason that, if you reject the New Jersey presumption, that the best interest needs to have some content. In other areas like relocation and custody, there's best interest. There's a whole list of factors established by statute or case law, and the family court order here says its decision is just the naked best interest because that's all there is.
But I'm not sure. Can you tell me why the child's best interests are served by picking one name? I'm having a little trouble with the fact that since this whole state is populated with kids whose names don't match either of their natural parents, or sometimes only one, how does this case differ from those cases in which kids don't share their parents'
This
name.
differs because these parents gave the dispute to a public dispute resolution in the courts, and most people don't. But when that happens, there has to be some formula or some list of considerations or some list of factors so that this naked best interest doesn't just revert to the predilections or the subjective thoughts of whoever happens to be sitting on the bench.
But you know what? I guess that really, I want to sort of challenge that question. Why is it we leave it to the best interests of we say the standard, let's say we say the standard is the best interest of the child, and we don't further articulate that. And you may be right that may mean that in case A, the evidence is exactly the same as in case B, and the only difference is that the judge is different, or it's a different, or that maybe the judge is the same. And in case A, the judge says the child gets the mother's name, and in case B, the judge says the child gets the father's name. So what? I mean, unless there is, the circumstances are such that we can really say, well, this is really, this is kind of outrageous that the judge did this, because the equitable considerations raised so strongly in favor of the other side against, than the judge did. If it's not that, so what? That on the very same evidence, the judge doesn't come to the same conclusion every time.
From a judicial point of view, it's a great big so what. I agree. From a personal point of view, it's obviously very symbolic, or we wouldn't be here. So, there is that
It's
problem.
symbolic in the best interests of one parent or the other. But as to the child, how can that be adjudicated? Child's 2 years old. How does the judge know?
Well, of course, and the best interest standard, obviously that's the standard, but it's unalloyed. It doesn't have anything to it.
Right.
Right? And so, what courts in all the other states, or lots of them have done, is set up a list of factors, and so that the court has something to consider.
Have state
to determine
legislatures acted in this arena?
Yes, I think they have. But standard lists, which is what we have here, no standards at all, what the courts are likely to do is rely on an unsupported allegation that having a name be so-and-so is going to help relations with parent-child relations, which is, pretty well discounted, I think, everywhere, or just out of convenience.
Well, wasn't that the
defer to
basis
social
for
convention.
Master Barber's decision here?
Pardon me?
Wasn't that, to the extent there is a record here to support a decision, wasn't that the state of the facts that she found? That it would be helpful to have a relationship with the father that had previously been
That is
abrogated?
what the judge found, and where this has been canvassed in the child literature and the legal literature, there's just nothing to that. And of course, there's no expert in this particular case trying to prove that either. So that's just an allegation that it's going to help.
How can we rule that
relations.
this is an unsustainable exercise of discretion?
Well, what I'm suggesting is that several things. One, that this isn't a discretion case.
That would be changing the rule.
Well, there's no rule really, because
Hence the brilliance of my formula.
right. If the judge is deciding a factual matter, what was the age of the parents at a certain time, right? That's a factual matter that deserves this court's discretion. But when there is the judge applied a name to a person, that has legal significance. That is a ruling of law, and that is not a deferential sort of finding. That's a ruling. So this is not a deference case.
Yeah, how are we sitting here in a better position to make that decision than the master?
Well, maybe you are, maybe you aren't. I think the problem here is that there's no standard at all for
Well,
anybody.
let's say we agree with you that the best interest, whatever that means, of the child is what the trial courts have to deal with. Then we would remand this case so that the trial court could apply that standard. It would then become a discretionary ruling, and the trial court would presumably be able to say, I find that in the best interest of this child, his name should be exactly the same as I said it should have been the first time.
If the petitioner can prove with some, with regard to some list of factors so that everyone knows what you have to prove when you go into a case like this, well, that may be the case. I think the problem here, the big problem here, is that we have a best interest standard that no one knows what it means. And so you...
Well, what would it mean? I mean, it's in the best interest of the child to bear only the mother's name because the father is a convicted child molester. Or it's in the best interest of the child that he bear only the father's name because the mother has committed welfare fraud. I mean, where do you hang this? These are two, presumably, decent people, I don't know anything about them, who seem to be fighting over control of the symbol rather than what's best for the child.
It is symbolic. The name is symbolic. But, that's clear. But whether, giving what the trial judge did, which is to give the child the last name of the non-custodial parent, that is not in the best interest of the child.
Why?
And that's why the New Jersey, because the custodial parent is the one that's going to be doing the day-to-day things that go into child rearing. So it is just simpler and easier for the child to have the name of the custodial parent.
You
Was that
raised
evidence
this...
in the record? Was that evidence in the record? Sounds to me like you're speculating or assuming.
I'm not sure it's an evidentiary issue, so I don't understand. I mean, it's a legal standard, I think.
Well, we don't know what's going to happen in 5 years. It could be the father who does the driving to school and taking to doctor's appointments just as much as it could be the mother. Nor do we know what's going to happen in 14 years.
And there is, throughout these name change cases, there is the problem of speculation, but I think that's true in probably most family law cases that involve children. There's plenty of speculation that go into the best interest of the child, and that's just the nature of it.
So if we were to follow the New Jersey standard and follow the custodial parent, if that were to change, does the child's name change?
Well, then there's the list. No, I don't think so. What I'm suggesting is that there ought to be a list of factors, which is listed in my brief, and of course someone having committed dastardly conduct is one on that list. But who is where does the child spend most of their time? Who is the custodial parent? The conduct of the parents, the financial support, and so forth. All those things ought to be, at the least, even if you don't go with a presumption, ought to be at the least some formula so that the courts know what they're looking at and don't
Just gave you one,
Well,
a formula.
when those circumstances change, would we be faced with another petition to change the name back?
Well, you might, but then in kicks one of the list of factors that other states have used, which is the age of the child or the preference of the child. At some point, these things don't switch back and forth.
You raised the issue of, that there's sort of a gender discrimination kind of thing here, that because customarily in the past the child has taken the
Right.
male parent's name. If we were to go with the sort of custodial thing that you suggest, I think it's probably a fair statement that today, and maybe even for some foreseeable time in the future, it's probably the case that most of the custodial parenting is still the responsibility of the female related part of the male female. So are we going to then get a claim by fathers that, wait a minute, this is a discriminatory impact. You've now replaced one discriminatory rule with another one.
That is the weakness of the New Jersey formula. That certainly is the weakness of it. And it's why I've also suggested that this court enunciate a list of factors that go beyond that.
Thank you.
Thank you.
Do you need to use your reserved time, Mr. Gordon?
I think Veronica came up with a good name for her child, and perhaps Master Barbara came up with a better name because it shared both parents. But the standard is best interest, not good interest or better interest. And what Master Barber did was put Mr. Lemieux's name last, and the middle name has no legal significance. And now the mother, who is likely to be the primary caretaker, has a different last name than the child. So it may be a good idea to include both names, but they're in the wrong order. And thank you very much.
May I just ask, the Goudreau case and the point that Mr. Crisp raised, what's your response to that in terms of the notion of custodial parents and names?
He made several points. The statute he talks about, there was a statute once that was like Goudreau. It was repealed. I'm not sure if that's what you were...
Well, it just, you don't dispute the fact that there was such a statute and that there was a repeal.
No, it was 1981, I think.
Thank you. Case submitted. Court is adjourned.